All right. Court of Appeal went with the District of the State of Florida now in session. Dan Trailer, judge presiding. All persons having business before the court of law here give attention to you will be heard. And God save the United States of America, the state of Florida, and then honorable court.
Thank you. Good morning. Welcome to an oral argument session of the Sixth District Court of Appeal. My name is Dan Traver. I'll be presiding today. I want to introduce you to the rest of the panel. To my right, your left is the Honorable Jared Smith. To my left, your right is the Honorable Joshua Mize. We have two cases on the docket this morning. Before I call the cases, I would just advise that we are being streamed live on YouTube, and that if you haven't already silenced your cell phones, I would be really grateful if you did. The first case today is case number 23-1658. Gentlemen, is the G silent or not? Silent. So William P. Battaglia individually and as co-trustee versus Robert E. Battaglia individually and as co-trustee. Before I recognize you, Mr. Brownlee, let me ask you guys both. There is in the docket a suggestion of bankruptcy and of automatic stay. There was a motion and an order which I presume lifted the automatic stay as it related to this case. It just wasn't in our appellate record. So I wanted to ask before we got started, are we violating a stay? Mr. Brownlee?
No, we are not.
Okay. All right. So you, are you making the argument this morning? How much rebuttal time would you like? 7? Sure. Whenever you're ready.
May it please the court. Mike Brownlee here on behalf of Bill Battaglia. Governors, this one's a bear. There's a lot going on factually and legally. I don't envy you having to weed through all this information. I think for purposes of today, the best place to start from our perspective is with what we think is the lowest hanging fruit, which is the damages issue. For many reasons, Your Honors, the trial court's damages ruling cannot be sustained. First, Bill did not commit a breach of his trustee duties. And under section 736.1003, that's dispositive on the damages issue. Because, and I'm quoting from the statute, absent a breach of trust, the trustee is not liable to a beneficiary for a loss or depreciation in the value of the trust property. So no breach, no damages. In addition, section 736.10021A, it's a mouthful. Damages are only awardable to restore the value of the trust property. Here, there was nothing lost by the trust. There was nothing the trust was entitled to. There was no depreciation. In fact, the only evidence as to the value of the trust, which is the stock shares in BFCIC.
Is that a full reading of that statute? Because it talks about restoring the value of the trust property and trust distributions to what they would have been.
Correct.
Okay.
Yeah.
So you just mentioned the first half. How do we address the second half? Are you reading it as synonymous?
I believe so. Yeah. I think the idea is restoration, bringing it back to, lost profits. It's what making the trust whole, I think is the way I think of it.
We've got at least some testimony in the record that there was an established way of doing things until 2018, which is when you had a property that was sold. That money would flow into BFCIC through whatever channels it came through, whatever single asset real estate entity had made the sale. And then you'd have that go to the trust for distribution.
Correct.
So there's an established way of doing things. So is there an argument to be made under that particular statute that the quote trust distributions to what they would have been would have encompassed that Trilago sale?
No, because there's no automatic right for the trust to receive that dividend, right? I mean, the company has to declare a dividend. The board declares a dividend, and only then would the trust be entitled to it. And that's 100% a corporate decision.
In your motion for rehearing that was filed below, you talk about the concept of, well, let me find your language. You talk about the concept of moving it from account 1 to account 2 for a reason that this is 5938 on the record. By analogy, it's as simple as having the funds in account 1 of the trust rather than account 2 of the trust. assuming arguendo, it's maladministration to have not moved the money to account two, such an action in and of itself does not reduce the value of the trust. And in this example, accounts 1 and 2 were assets of the trust. So I understand that argument to mean that if you're dealing with account 1 and account 2, the argument is there's an inappropriate amount of damages here because your client is going to be entitled to 1/2 of whatever's distributed from BFCIC to the trust.
Right.
And I don't know that that's a crazy argument. However, it seems to undercut the argument that you just made, which is that these are separate corporations with separate corporate indicia.
I can't speak to how it was phrased in the motion for rehearing. I suspect that was for simplicity's sake. I mean, it's not account 1 and account 2 of the trust. It's a corporate account. And then you've got the trust account. I mean, those are 100%, and the record bears out that those are very separate accounts held by very separate entities.
Mr. Brownlee, how do you read the final judgment? When I look at the final judgment, it says that, Mr. Battaglia shall pay individually the, $2.2 million. While at the same time, the money may still come up through the entities for distribution. I think I saw something in the record that indicates it actually has since then. So do you read this judgment as essentially permitting that distribution to come up through the entities and for them to collect against your client?
100%. It's at least the potential for a double, but there's certainly there. I think it's outside the record where that money has gone. My understanding from the records that it's in those corporate coffers still, but absolutely. I mean,
Well, the record reflects that it's been distributed with rights on appeal. So there's a satisfaction.
correct. Sorry.
Yeah.
That's correct.
So that is part of the record.
Right. Okay.
Right. So if the money has come up through the entities and has now been distributed to the trust, your position is there's still that has not satisfied the judgment, that the judgment imposed separate independent liability on your client that needs to be reversed.
Yes. 100%. I think that's the only way to read the judgment.
Yeah, I guess we'll just ask your colleague what the defensible argument is, if that's so, whether he's going to adopt that or not, because it doesn't seem that you look at that statute, that extra half of the $2 million, the big chunk of the damages, there's not a situation where your client still isn't a trustee.
Correct.
Okay.
And again, I know that I'm concerned about the account 1, account 2 verbiage, because to the extent the court's thinking about it that way, I think we have to be careful. It was
your client's position.
Understood, but I don't think that's reflective of the position they took out throughout the proceedings. I think that's the way he phrased it in the motion for rehearing.
Yeah, and I mean, for what it's worth, it's a phenomenally detailed motion for rehearing. It's 26 pages long, so it doesn't leave anything on the table.
Right.
Okay.
I think the next, and then removal also, for a lot of similar reasons, removal was not appropriate.
Let me just ask about
Please.
quickly the remaining 2 items of damages. You've got the interest on the Joe Frame advance, and then you've got the Nelson Mullins.
Correct.
There is some contention, I can't recall whether it's in the motion for rehearing or it's in your briefing, that suggests that the Nelson Mullins legal fee advance had to do with a BFCIC matter. I didn't understand that to be true. Okay. I understood it to have to do with the Luma litigation. Correct. Is there some place that you could point me to in the record that suggests that it was a BFCIC matter?
I need to get back to you on that, but
okay, sure.
I don't know the location, but I know for sure that the record reflects that BFCIC was the parent company basically of the subsidiary that was at issue, and it was a landlord in the Luma litigation.
So I guess that's the argument, because again, it seems like if you're going to argue on one hand that we're dealing with individual corporate formalities between and among corporations and trusts, that the same thing has to hold true, that if it's the Luma issue and it has to do with a single asset entity that is not BFCIC, I don't know that you can get the benefit of both sides of those arguments.
Understood. And again, I don't think that's too fleshed out in the record. I don't know if the management agreement permitted that kind of use for legal fund. I mean, I don't know.
Okay.
But again, those are corporate decisions. The only party in this case is the trust, right? There's no BFCIC, not a party. BPL, not a party. None of these entities are parties here. And those are corporate decisions. How legal fees are spent. I mean, those are corporate decisions that shouldn't have been an issue ever for damages or really anything else. And pursuant to the trial court's own pretrial rulings, that's the sort of the state of affairs going into trial, which makes the result very hard to explain.
Yeah, I didn't see many, because I think it's just analogous to corporate law, right? If the owner of these entities wasn't a trust, if it was a parent company, if a subsidiary has some kind of lawsuit and it's damaged and it goes after somebody, the parent company can't sue. I mean, if Coca-Cola has a subsidiary that does bottling and it has a breach of contract or a business tort, Coca-Cola can't sue. The company actually injured has to sue. I didn't see kind of a detailed of the kind of, I mean, I saw the assertion, I saw the argument. I didn't see a lot of precedent kind of detailing, as a matter of corporate law, why that is and examples of parent companies not being able to collect. Is there any reason that the law in that area didn't graft over into the trust context when a trust is the parent company? It seems to me that would operate the same way, but I didn't see anything in the brief where it says, hey, here's how this works in corporate law and how we all expect. And, here's why there's no reason it should be different in the trust context, or nothing about the trust code makes that any different here.
I think I understand your question. The Parker versus Schulman case out of the Ford TCA, that's where I would direct you for the best. That at least has a description of, it's a similar situation. Trust owns stock in the company, and the challenge, the company is not a party, and the challenge was to the corporate compensation of the trustee. And the Ford TCA says, no, you can't, unless the corporation sued and you bring a derivative action, and you can, do all the other things you have to do to comply with corporate law. You can't, it's not a trust issue. That's as close as I can get.
You wanted to talk about removal. You got 3.5 minutes before your rebuttal time. So please, however you see
I think
fit.
I'll reserve, actually, unless the court has any more questions.
Sure.
So I'll
Please.
just throw out one question, Mr. Brownlee. So that with the 2.049 million for the failure to distribute the trust proceeds, the sale proceeds. My understanding is, and this has already been discussed, it's been moved into an account essentially ready to be distributed at this point in time, correct? So let's say it gets distributed. Isn't that a post-judgment set-off for your client? So isn't that issue presently moot?
I think not, because I mean, this is the problem with the separation of the corporate entity and the trust. I mean, well, I guess I don't understand the question.
Well, I mean,
how do you-
once that money gets into the hands of the beneficiaries, isn't your client then going to say, Judge, we get a set off for this judgment that's currently against us in the amount of?
In a perfect world, but now we've got a lot of different, the damages award is against my client personally. Right, so I don't know that he'd be able to get a set off. If that's a deduction from the corporate coffers.
I think the problem is judgment says he's personally liable.
Right.
And maybe there's a 1.540 inequitable enforcement sort of defense.
Maybe you'd love to not be there, though.
No, I get it. I get it.
Yeah.
Okay.
Okay.
Thanks,
you,
Mr. Brownlee.
Bench.
Yes, sir. Good morning.
Morning. May it please the board. Bill Spivey and Courtney Keller of Greenberg Trorick on behalf of Robert Battaglia, who I will try to refer to as Bob this morning for purposes of avoiding potential confusion. The trial court got this right.
Counsel, can you start with the first question we asked about the judgment?
Sure.
So if those distributions were to happen, right, so the money from BPL and BFCIC comes up to the trust, is your position that Bill Battaglia still owes the $2 million under the judgment?
We don't care where the money comes from. I think Judge Smith hit it on the head. This is a matter of collection and a matter of enforcement.
I guess what I'm saying, but do you view that as the judgment being satisfied? So if that just, your client's the trustee now, or Bill's the trust, or Bob is the trustee now. If Bob distributes that money, if it comes up from BFCIC and BPL to the trust, and Bob distributes it to the trustees, which is half to him and half to Bill, has the judgment, at least the distributions part, is that $2.049 million, has that been satisfied?
When that happens, it will be satisfied.
Okay.
Yes, sir.
Okay. So your position is that whatever individual liability there is not duplicative of the distributions actually happening. And if they happened, your client cannot collect from him individually that $2.049 million.
We're not seeking a double recovery, to answer your question. If we get the money through the chain of entities, we'll be satisfied.
Okay. I guess I want a little more of a definitive answer. If that distribution comes up,
Yes,
do you concede your client cannot collect on any additional money for that 2.049 for the distributions part, for the BFCIC and the BPL distributions? if that money comes up and is distributed to the trust and then distributed to the beneficiaries, do you concede your client cannot then collect any other portion of that money from Bill Battaglia individually?
Correct. Yes, sir. I think the potential misunderstanding here arises from what really underpinned the court's determination is that all of these funds were opportunities. And if you look at 736-0802 subpart 4, the legislature speaks of opportunities. Bill Battaglia had an obligation to maximize every opportunity that was available to the trust. And he put himself in a hopeless conflict of interest that required him to either resign or to get guidance from the court. And it's ironic that he didn't do any of that. Instead, he set out on a unilateral course of tyranny that, frankly, I think is unprecedented in the jurisprudence. In all the cases that we looked at, I can't find anything remotely close to the kind of conduct that Bill Battaglia engaged in. He was openly hostile to his co-trustee. He was openly hostile to all beneficiaries. He excluded Bob Battaglia from every decision that was made. He instructed other people not to interface with Bob Battaglia, not to give him the information. You'll recall that Bill Battaglia testified that he viewed Bob as an obstruction and the biggest waste of my time. That's not fiduciary behavior. That's not how you interface with your co-fiduciary.
Can I keep you on the damages, counsel? So if we go on to the next category, the legal fees and the interest thereon, I'm trying to think of any other context where a company suffers damages, right? Those entities suffer damages as a result of Bill Battaglia, at least according to the judgment, as a result of him spending money he shouldn't have from the entities. And so I'm trying to think of any other context where a company suffers damages, and rather than that company taking legal action, the shareholder of the company's parent entity, right? I know it's not a business entity, but it's an entity, it's a trust. The parent entity that owns the subsidiary that was actually damaged can sue for damages directly on behalf of the parent entity based on damages actually suffered by the subsidiary. Is there any other place in corporate law where that's a thing?
Respectfully, I don't know that analogy applies to this circumstance because this is a trust. And Bill Battaglia was obligated under Florida law to act solely in the best interest of the beneficiaries. This isn't a corporate context where there are parent entities and subsidiary entities. And I submit that the fiduciary obligation imposed on Bill Battaglia as a matter of law exposed.
I think what you just said there is not correct. I mean, a trust is an entity, right?
Sure.
Okay. And a trust can own a subsidiary. A trust can own an LLC, right?
It could, yes.
Okay. If it owns an LLC, then it is the parent entity of that LLC, correct?
Yes, sir.
Okay, so the statement that this is not a context of parent entities, that's just obviously false, right? That was incorrect to say that.
If I misspoke, I didn't mean to, but I think there's a distinction between being a trustee and being a corporate entity.
Well, but that speaks to whether, I guess, is like whether or not he should have done it. I'm talking about where the damages flow to, right? So you have an entity that suffers damages and it has a parent entity. Normally in the corporate law context, you would expect the entity actually damaged to have to sue to recover that money. A parent entity cannot just sue directly to recover damages suffered by its subsidiary. So I think that's clearly how it works in corporate law. That's what happened here. So I guess I need you to tell me, why is it different in the trust context? What about there being a trust as the parent entity means that it can recover damages suffered by a subsidiary? Is that always the case with trust? Do they have some kind of different, are they different in corporate law somehow where they get to sue for subsidiaries damages where other parent entities do not? Give me the basis for that distinction.
Look at 736.0802 subpart 6 that talks about when a trustee is voting shares or acting in a corporate capacity on behalf of some related entity. He's obligated to always look out for the best interest of the trust. And I think that is a critical distinction here that gets you out of the hypothetical that Your Honor described, is Bill Battaglia's breaches of fiduciary duty exposed him to liability for every opportunity that was available to the trust in which he failed to pursue. He was on a hopeless conflict of interest that he could not just unilaterally resolve as he saw fit. But
So
that's,
when you talk about, Mr. Spivey, you talk about 736-0802, that's a liability, what a trust or what a trustee can and can't do. If I'm looking at the damages statute, which is the 736-1002 sub 1, which talks about how we categorize damages when those things occur, which I think is a separate issue. It talks about the amount required to restore the value of the trust property and trust distributions to what they would have been.
would have been.
Do you view those as two separate categories of damage, or like Mr. Brownlee, do you view them as interchangeable and the same?
No, I view them differently. And I think the would have been is consistent with the opportunity verbiage in 0802.
Okay, so if you've got on the first hand, you've got restore the value of the trust property. Are you suggesting that the Nelson Mullins loan and the Joe Frayne interest were trust property?
Yes,
Help me understand that.
they were opportunities, again, Your Honor.
What's an opportunity like that? I mean, the allegation is he took money he shouldn't have. I get what like a business opportunity is. Taking money out of a bank account you're not supposed to. I'm confused by the use of the term opportunity to refer to that. I can see misappropriation of funds. I don't see why you keep using the word opportunity.
I'm taking it from the statute, Your Honor. That's where I'm getting that. And there's some case law that speaks of a trustee usurping opportunities.
But how does this fall into that category? It wasn't a business opportunity where he's like, do I want to pursue this or I want to let the trust pursue it? He took the judgment found he took money out of a bank account he wasn't supposed to. It was put it to somewhere he shouldn't have. It was a bank account of the subsidiary. Why does that fit into the opportunity bucket?
That money should have flowed to the trust. It was
Can
an
you help me
opportunity.
can you help me understand that? So I understand, there was record evidence about the common way of doing things,
Mhm.
Before this failed succession in 2017, 2018. Is there anything in the record that suggests that that particular money, that $100,000 or that $3,000 would have in the normal course of business flowed to the trust, either generally or specifically?
It should have, but for
Yeah, I'm just
Bill
asking where.
Battalia's breaches.
Well, I'm just asking where in the record that happened, because I understood the normal way of doing things with with BFCIC and the subsidiaries underneath it, was that they had to run a business. So there's operating costs, there might be carry costs, there might be property taxes, all of those sorts of things. But then when one of those LLCs was sold, that's when things would distribute up. How do I view the Nelson Mullins and the Joe Frayne? Do I view them in the bucket of being a sale that goes up, or do I view them as being misplaced operating costs? Or am I making an incorrect distinction?
Again, I think it's cash that would and should have been available for distribution to the income beneficiaries, which was Bill Battalia's obligation as the,
What's the CSE that it actually would have been distributed?
I'm sorry?
What's the competent substantial evidence that it actually would have been distributed? In other words, what if they had that extra money, they would have given the employees a little extra Christmas bonus that year. Like they wouldn't have distributed up. They would have used business judgment. Since they had the money, they would have used business judgment and decided, yeah, it's in our interest to give employees a bonus this year. That's a competitive labor market. Just because they had it doesn't mean it would have been distributed up.
Respectfully, I don't think that Bill Battaglia is entitled to that indulgence, if you will, because he did all of this secretly, unilaterally, without any consultation whatsoever with his co-trustee.
That goes to liability. The damages that restore the distributions to the trust that would have been. So the fact that you think he's like really obviously guilty, that has nothing to do with whether or not these monies would have been distributed up, counsel. That seems to me to be different issues.
I think the court had sufficient evidence before it to find that those monies would have and should have flowed.
So my question was, what is that evidence?
I think it was a testimony of Bill Battaglia.
He testified if that money had not, if they had had the interest on those monies,
No,
he would have distributed it up, because I
Bill
didn't see
Battaglia
that.
did not testify about interest on anything.
Okay.
But I think his testimony about the established pattern, the established course, I think that was a sufficient predicate for the trial court to find that those funds would have and should have been there for distribution to the beneficiaries.
Yeah, and I'll just ask one more time because I'm a little bit hung up on the same idea, perhaps as my colleague is, which is, where in the record does it specifically talk about anything other than property sales being distributed?
I don't know that it does, Your Honor.
Okay.
I can't point you.
Is that a challenge for you then?
Sure.
When we're talking about money that was sent off to pay a Nelson Mullins retainer for something that might not have been BFCIC business?
I don't think so. Certainly with the $3,000 accrual, that is in a different category. But there were $350,000 that Bill Battaglia diverted from BFCIC for his own personal benefit. Okay. I think there's absolute liability for that. And I think there's certainly a expectation that that magnitude of money would have flowed to the beneficiaries of the trust.
So basically, if I understand you correctly, you're saying that the 110, the Nelson Mullins retainer, is effectively compensation for him, otherwise taking the 350 out.
Yes.
Okay.
Yes, sir.
Also, in other cases, if you have a subsidiary and the CEO of that subsidiary, embezzles money from the subsidiary, isn't it the subsidiary that has to go after him rather than the subsidiary's parent company? I mean, if you had the Coca-Cola distributor, right, that's a wholly owned distributor of Coca-Cola, and it's got a CEO, and Coca-Cola finds out that that CEO of the distribution subsidiary has been stealing money or took money for his own funds, they would go after him on behalf of the subsidiary. The subsidiary would say, return that money. The parent company couldn't itself directly go after him, could it?
I think the distinction here, Your Honor, is that Bill Battaglia is part of that parent entity.
So as a matter of corporate law, okay, say he is also the CEO of the parent entity. Say the person is CEO with the parent and the subsidiary, which can happen, and he takes money out of the subsidiary's bank account. Does the fact that he was involved with the parent company as a matter of corporate law mean the parent company can sue him for damages suffered by the subsidiary? I mean, you're a corporate lawyer, Mr. Spivey. Is that how it works?
I think it does in this context, Judge, because we have this trust statute that does not exist in the corporate world.
All right, so give me the language of the trust statute, which you would say this changes how basic corporate law works.
It's the two statutes that I referenced, 0.1002 and 06.
What part of that language changes the basic structure of corporate law if a trust is involved? Read me the words. What? Because I don't see anything in there that says trusts operate differently when they're a parent entity than every other type of parent entity in all of corporate law.
Trust law gives us the opportunity to pursue opportunity losses. And Bill Battaglia created enormous opportunity losses for the trust.
Can I ask your question in a slightly different way?
Sure.
If we reverse on the Nelson Mullins retainer, does BFCIC have an action against Bill individually for usurpation of corporate opportunity?
It probably could.
Okay.
I mean, Bill Battaglia could be sued any number of ways. I mean, against this pattern of misconduct, there are any number of people who could sue him. He certainly engaged in corporate mismanagement. He engaged in trust abuses. He engaged in.
If the subsidiary can sue, that really seems to cut really strongly against your argument, because that kind of speaks to the fact that it's the subsidiary's lawsuit. What you told me, it's different in this case because as a trustee, he had a duty to the trust. Well, the CEO of a parent company corporation would have a fiduciary duty to the shareholders of the parent corporation, wouldn't it?
The fact that one party could sue another doesn't mean that that's the whole universe of who else could sue.
Okay, but you said it was different because, well, the trustee, this works different than all other areas of corporate law because there's this trust statute that imposed a fiduciary duty on him as the trustee of the trust. Well, the CEO of a parent company that was an LLC, it would have a fiduciary duty to its shareholders, right? I mean, don't corporate officers always have a fiduciary duty to their shareholders?
Of course,
Okay, so why is that a distinction between a trust and another entity that's a parent company?
because the trust statute speaks of opportunities. And I
No,
think
but corporations speak of, the corporate law speaks of opportunities. Corporate officers cannot usurp business opportunities from the corporation for which they work. I mean, their corporate officers can be sued if they do that. So the fact that there is an opportunity to, an obligation to account for opportunities to the trust, that doesn't make it unlike other entities. That makes it exactly like other entities, right? Does not the CEO of a corporation have a duty not to usurp corporate opportunities from the corporation? Isn't that basic corporate law?
that is true.
Okay, so why is that a distinction between another type of entity and a trust rather than evidence that they work the exact same way? The distinction you gave me is not a distinction.
Again, I don't mean to be argumentative with your honor, but I think the statutory scheme of 1002 and 0806 exposes Bill Battaglia to liability for all these things.
When I asked you why, you said because of this opportunities language.
Yes.
Okay. So that also exists in other types of entities. So why is that still a good argument?
It doesn't exist in statutory framework. I mean, it was a common law, right? But I don't think the statute, chapter 607, the corporate statute, I don't think it has this opportunity language that's in 0806. I think
I guess I'll ask you a question. Would this mean that if we were to write an opinion of affirming those damages, right, and saying that a trust can go after a subsidiary's damages, provided the damages are caused to the subsidiary by a trustee of the trust, that'd be pretty set in a statewide rule now, right? That whenever a trust owns a subsidiary, if the trustee damages the subsidiary, the trust can sue the trustee directly. That'd be the rule across the state now.
if you fashioned it that way, it would.
Is there any way to write an opinion affirming that doesn't fashion it that way?
I think you could.
What would that be?
I think the Diamond Trust case we cited in our briefs. Trustee served in the corporate opportunity. And in that case. I have. Just remaining. Bill Battaglia is not entitled to any favors here. He engaged in all acts and for deficient and vulnerable in any number of ways. There's nothing about his.
Are any of the
conduct-
legal standards for damages here involve benefit of the doubt based on somebody being a bad guy?
I'm sorry?
Do any of the legal standards for damages we have to apply here involve saying somebody doesn't get the benefit of the doubt because they're a bad guy?
Damages are damages, and they
Okay.
have nothing to do with.
Okay, so
whether-
why is it relevant to say, well, listen, keep in mind you decide this, he's a bad guy? That doesn't seem like a legal argument to me.
This is a court of equity. And I think the trial court tried to do the right thing, and I think it did do the right thing. It found Bill Battaglia to be a very unsavory fiduciary. The findings of fact are unrebutted. Most of the case came from Bill Battaglia's own mouth. And most of the case came from Bill Battaglia's own unilateral acts that happened after the litigation was filed. When the litigation was pending, Bill Battaglia was out doing all these unilateral outrageous things. And it was very displeasing to the trial court. And I would request the court to affirm this in all respects.
Thank you, counsel.
Please, court.
Yes.
Your Honor's awful, horrific. This is in large part why we got here. That opening of Mr. Spivey's statement.
Mr. Brownlee, I don't want to interrupt, but
Please.
I have to. We only have so much time. So you just heard obviously counsel for Mr. Battaglia say that his particular stipulation, I'm going to ask if you would join with it. Do you join with Bob Battaglia's counsel's stipulation that if the 2.049 million distribution goes forward, that would satisfy the $2.049 million individual judgment against your client? Do you join that stipulation that he just made before us?
I don't, as I sit here now, I don't know.
Is there a reason that you wouldn't? I mean,
No, I mean,
he basically said it's a
suppose-
50% haircut.
I suppose so, but it sure seems like a roundabout way to go about it.
Well,
I mean,
hold on. I guess it goes to how do you read the judgment, right? I mean, what you're putting your brief to us and argued was this judgment allows for double recovery, right?
Right.
And that's one of the main arguments. And obviously that would be a good argument to allow for double recovery. I think what we have is a matter of interpreting the judgment, a stipulation from the other side. We don't read it that way. We don't believe we have a right to enforce it. I think there was a pretty definitive concession that if that money is distributed up, that portion of the judgment is satisfied and we cannot go after Bill Battaglia.
well, I'll take it.
If that was a correct
I
reading
think
of,
that's what.
I guess what I'm saying
I'll
is,
take it. And I don't mean to
assume,
look-
I'm not saying you agree with that reading of the judgment.
Right.
But if that were the correct reading of the judgment, as a matter of just interpreting it, that would eliminate the double recovery problem, right?
I suppose that's right. Yes.
He would have had a very different experience up here if he'd have said he could still get an extra $1 million.
Yeah,
out of it.
I suppose so.
So with him conceding that and you agreeing to that concession, does that then at this point moot the appeal regarding the $2.049 million individual judgment against Mr. Bill Battaglia?
From a damages perspective, I suppose, I mean, maybe, but I suppose so. But the problem.
Nobody's asking you to moot any other aspect of your appeal. This was a
Okay.
200-page collective briefing. There were lots of things that were argued.
Understood.
Yeah.
Then yes, I suppose it does. Your Honor, the beginning of Mr. Spivey's presentation about this is unprecedented in the trust cases. It is the exact opposite. Okay, if you read any of the trust cases for removal damages imposed against an individual trustee, they are actually horrific things. They're stealing. There's violations of the duty of loyalty. My client tripled the value of this. I mean, tripled a fortune.
Because
over
I
his-
think you heard my question, your opposing counsel. I don't think any of the legal standards we have to apply based on, for the damages here, go to level of badness or lack of level of badness.
Correct, but it does for removal, right? I mean, and just in a general sense, I mean, this is a hard.
Let me ask you this on
Fine.
removal. You have this lack of cooperation prong, as the basis for removal, which seems to me to be pretty broad, right? Was a trial judge looking at the lack of cooperation? Was one of the things a trial judge could take into account the family dynamics of this trust? In other words, could he look at two sides and say, I've got one person and then I've got, every other person in the family, and there's been a complete breakdown. If it's like 14 or 15 against one or however many on the other side, I can take that to mean he's the problem and there's a lack of cooperation. Like, isn't there a lot of broad reasons you could look at that as a lack of cooperation, including nobody in his family will speak to him? That was in the record on either side. Like, isn't that on its own enough to show lack of cooperation, at least at a CSE level? I mean, we're not here as fact finders, we're here as CSE reviewers, right?
Understood. If the statute said, just lack of cooperation, stop there, maybe so, but it says a lack of cooperation that substantially impairs the administration of the trust.
Okay,
The
so
trust in this
every
case doesn't-
single other person involved in the trust at every single level, in terms of the beneficiaries and the trustee, won't speak to him and hasn't spoken to him for years. You don't think that, I'm not saying that it means who's right? Even, that doesn't even speak to who's right in that dispute, right? It just speaks to, for whatever reason, every single other person who has an interest in this trust will not speak to him and he will not speak to them. And just as a matter of administration, it's a lot easier when you have 14 or 15 people with an interest in one,
yeah,
it's a lot easier to get rid of the one, right? Could a trial court now look at that and say, just that dynamic, however you got there and whoever's fault it was, impedes his ability to operate the trust?
Maybe, but not in this case, because you have to substantially impair the administration of the trust. The trust in this case doesn't do very much. It collects, if a corporate distribution is made, dividend is declared, the trust is distributed. I mean,
What about his demeanor in court? Okay, so the trial judge is entitled to evaluate, right, the witnesses and determine, what do I think about this person, right?
Sure.
Okay, and he made some harsh findings to your client, right? Can that not be CSE of, all right, is he not allowed to look at this person and say, I've personally watched him testify. I've seen him interacting in the courtroom with his family members. I don't think he can cooperate with the rest of the family in a way that, is functional and allows the trust to operate well.
If there was evidence that was impairing the administration of the trust, I would say yes, but there's not in this case. I mean, the most of what the trial judge was talking about were the remainder beneficiaries who have extremely limited rights under the trust agreement. I mean, they
have knowledge rights, and it's hard to exert those knowledge rights if they can't speak.
but you can't just not speak to someone and then say, we're not getting along. I mean,
He didn't. I think the evidence showed neither one wants to speak to each other. So your client doesn't want to speak to them either, right? Well, that's a two-way thing.
Right. I would just say there's no evidence that that the administration of the
Yeah.
trust was ever impaired.
The other thing I didn't
Trust
get on
fund.
these disclosures, there were 7 years of lack of disclosures, and the argument in your brief basically was, well, we just all, Bob and I together decided not to do the disclosures for 7 years. And to me, that really doesn't mean there wasn't a breach. It just means it sounds like Bob agreed to the breach.
I agree.
Right.
with-
Okay, but that doesn't mean everybody else agreed to the breach, and it doesn't establish a lack of a breach, and nobody's suing to remove Bob.
Yeah.
Right? So I didn't see anything in your brief that would establish that wasn't an obvious and clear breach of the trust code.
I would agree that it was. I would
Okay.
agree It was, but it was cured. I mean,
Okay, but does the removal statute say breaches that are later cured cannot be a basis for
no,
removal?
they say it has to be a serious breach. When it comes
But
to
but
removal.
serious and cured are two different things, aren't they?
Right, I would argue that the failure to account was not a serious breach. I mean, there's
Okay.
not much accounting to be done.
Okay,
If
but
you
the
look
fact
at
that
the
it was,
accountings, they're
but the
not.
fact that it was cured certainly has nothing to do with whether it was serious to begin with, does it?
No, it doesn't.
Can I ask you just in the legal, because you're running out of time, the interest and the legal fees, all right? Can you tell us why your opposing counsel is wrong that that operates differently when the parent company is a trust than it would if the parent company was some type of corporate entity?
Basic corporate law, I mean, everything that you were suggesting, I mean, that's not how it works. Those are corporate funds. It
Can you
was
respond to this argument that that falls into this opportunity bucket under the statute?
opportunity for what? I mean, the trust had there was no opportunity for the trust just because those funds were sitting in BFCIC's coffers. That's not an opportunity. It's not nothing is an opportunity until there's a dividend declared by BFCIC. To talk about it as an opportunity is, I think, thinking about it in completely the wrong way. There is no opportunity. There is a duty to distribute by the trustees if and when money comes in. That's it. Otherwise, it's a derivative action. And your honor, my client testified at length about all the reasons that 2.4 million wasn't distributed. It would have been a horrible idea from a corporate standpoint to do that. I would encourage the court to read that testimony, and he should be entitled to the business judgment rule. He should be entitled to there should have been derivative suit compliance. I mean, you can't just latch on all of the stuff to trustee law when it's basic corporate law. I see I'm out of time. Thank you, your honor.
Thank you both for your presentation. We'll take the case under advisement. Yeah, we'll take a 5-minute recess. Might be closer to time. Please be seated. We'll be back on the record. Our second case today is case number 23-4087, J. Stephen Gibson versus the state of Florida. Mr. Bark, how much time would you like for rebuttal? Oh, Mr. McLean, right on.
5 minutes, Your Honor.
All right. And I should recognize you, sir. I apologize for that. Okay, whenever you're ready.
May it please the court, Matthew McLean and attorney Matthew Spark on behalf of the appellant Chase Gibson. I'm hoping today that the issues that we present are a little simpler than the first case that was heard by this.
All right.
I have no envy of the corporate and trust law context. Today I'd like to group the issues essentially by 2 categories. The first one has to deal with the right to counsel and right to self-representation. And then the other 2 have to do more with what happened at the trial itself. Starting with the first briefed issue, Mr. Gibson, after the court conducted a Nelson inquiry, moved for a continuance so that he could retain private counsel. The defendant has a constitutional right to counsel of their choice. In the context of moving for a continuance to obtain counsel of choice, it is a balancing test the court must go ahead and use to make a determination of whether.
Why is it a balancing test?
Because the defendant has a constitutional right to counsel of choice, and the court has the right to manage their caseload. So there's a balancing between the 2 of those.
I guess one question is who has said it's a balancing test?
Precedent from
Other
the
DCAs?
DCAs, correct.
Are we bound by those other DCAs?
No, Your Honor, based on being the new 6th District Court of Appeal,
Yeah.
you
So-
can go ahead and.
Correct. So I think there are cases in your brief that obviously clearly stand for the proposition the trial judge was required to do an inquiry, right? And variety of things, some of the DCAs state it a little differently, but things, at least the first and the fourth, have clearly said there needed to be an inquiry at which certain things were considered, then she can make a ruling, and she didn't do an inquiry, and she just denied it. I'm thinking of it as a matter of first impression, right? We're not bound by those DCAs. I didn't see anything from the Florida Supreme Court. Why was she required to, not relying on the other DCAs? Why would that be right? That she's got to do a specific inquiry orally, right? As opposed to just read the situation herself and rule, right? I mean, because that's really the distinction. Was she required to discuss this in court before ruling? Or could she presumably consider those things in her head and rule without discussing it? The other DCAs have said there's got to be a discussion. And other than saying because other DCAs have said it, why is that correct?
Well, I'll start out with, there's no DCA that I'm aware of decision that says that there's no inquiry that is not needed. So this would be, an outlier jurisdiction. So if the court does take that position, it would need to certify conflict on the issue. But as to why, I think the purpose of it is to prevent from arbitrary denial of motions to continue when there's accompanied a right to choice of counsel as well. So it's in order to actually.
Can I ask you about the first thing that you just said? Because I notice evolution in the cases. All the way up until Deal, which is the 4th DCA case, it talks about doing 2 separate things. It talks about making inquiry, or it talks about whether there's record support for something. And then we move on to, I'll mispronounce it, Cardozo, Balsaron. Those particular cases seem to throw out the notion of the record supporting it. Is it your contention that there always has to be an inquiry, even if the record doesn't support the need for one?
Yes, there always needs to be inquiry according to the.
Where does that come from? So to go on Judge Mize's questions to you, as a matter of first principles, you say that, and I think there may be something to your argument, that the idea here is to safeguard the constitutional right to counsel, right?
Correct.
If the record supports that it is being done for delay, or it's frivolous, or for some ulterior motive other than to support the right of counsel, why would there need to be an inquiry in that situation? And look, I'm not touching your case for the purposes of that question. I just ask you to answer it in a legal vacuum.
I think if it's, I think all the courts, they kind of go through this analysis, even saying that there must be an inquiry, they go ahead and they follow up and say, well, in this case, it looks like there was not any sort of bad faith within the record. So the courts kind of strike a balance from there must be, and then they kind of go into Well, in this case. we
Does
look at
it
the
matter that
circumstances.
if we were to look at whether there was support, like had there been an inquiry, the trial judge obviously could have made the same ruling, that there was a plethora, a wide amount of what looks to us like support for her ruling. She just didn't do the inquiry before making it. Is
Well,
that significant?
Well, there's three factors, right? So there's the first factor is bad faith or as a delay tactic. And so there's support from both sides that this was in good faith. And
There's
bad
support for both sides, right? It's abuse of
Correct.
discretion. That means there's support for her ruling, right? So by saying there's support for both sides, you just conceded she could have made this ruling had she done the inquiry, right? Because if there's support for both sides, that means she can do what she wants. It's abuse of discretion,
I
right?
think had she done a proper analysis, then she would have made the determination, but we don't know how she ruled on the issue because there's no recognition from the court that it was recognizing his right to counsel at the time and balancing that with this.
You're right. You're right. She didn't do the inquiry.
Correct.
I agree with you on that. I'm not disputing it. I'm just saying, does it matter if we determine that, hey, she didn't do the inquiry? Had she done the inquiry, we think there was plenty of support in the record to sustain her ruling had she just done the inquiry first. And so this isn't a case where there's a problem with the ruling itself or there wasn't support for it. It's just the fact she didn't discuss it, right? If you were to get a reversal on that issue, and if we thought there was support for her ruling, but you got a reversal anyways, you'd be getting it not because she was wrong, but just because she didn't discuss it on the record first. And I agree with you. That seems to be what the first and fourth have said. Okay. And I guess what I'm saying is, are the first and fourth right about that? Like, what is the first principles explanation for why, in order to respect his right to counsel, she had to discuss this before deciding he was doing it for improper reasons?
Well, I think if you want to protest against arbitrariness in denying motions to continue, then that's what you need to go ahead and do is you need to have an open discussion. And the case law told the court at the point in time, which she was bound by, to go ahead and do that inquiry. So I don't want to go ahead and say for this court to.
It's just policy then?
I think it's good policy. And,
Okay. Is there any, I'm not saying that's not a valid thing for you to argue, but is there any, other than policy of like, hey, we think this will facilitate discussion and protection of the right, and so it's a good rule to impose. Other than policy, is there any kind of legal first principle why we should adopt that?
I think, yeah, it also aids appellate review to determine the arbitrariness of the ruling. And when you look at the other two prongs, we're kind of been talking about the first one, is this going to prejudice the state, the continuance? There's no objection. There's no evidence at
Okay,
all.
I'm not talking about
Support
whether
that
the ruling was good or bad. I'm just talking about whether or not an inquiry had to be made before making the ruling. To me, that's the key issue there is the lack of an inquiry.
I think it's a must. It's a must. And I would go ahead and cite to all the DCAs that go ahead and say that that's at this time.
Even the ones that say that if the record has enough in it, that you don't need to do the inquiry.
Well, I don't see any decision that's been cited that hasn't resulted in reversal. So it's kind of almost dicta in a way that they're going through in this situation. This is would support a
I
good
understand
faith.
your answer. Could you move to the second issue?
Can I ask one more
Oh.
question on that? So the cases, I just want to make sure I have a comprehensive list here. The cases that you would say support your proposition that there must be inquiry anytime there's a motion to continue. I have Deal, Alvarez, Jones, Foster, Perozzo, and Valcarcel. Those were cited in your brief, I believe. Any others that you're relying on here today?
I think the other one is Madison. They take a little bit of a different approach and look at the McKay factors. But ultimately, I believe Madison also talks about that as well.
Okay. Unfamiliar with Madison, and I apologize, but at least in regards to Deal, Alvarez, Jones, Foster, Perozzo, and Valcarcel, in all of those cases, every one of them, the name of the proposed attorney was known to the court, made known to the court at the time of the motion to continue. And the attorney was either retained already or personally appeared to make that motion to continue. Do we have either of those in this case?
I would point the court to the Deal case as well. In Deal, the attorney was named, but he was not present, had not went ahead and made any sort of appearance in the case. In Deal, it was essentially the public defender telling the court that the family had indicated to the public defender that the family was looking to retain counsel. And so in this case,
Well, no, the mother actually said that she'd already retained counsel. So, and there was no question that counsel had already been retained. I mean, from a factual standpoint, the appellate court was treating that as knew the name and mother represented that the person had actually been retained. There was no question that, was the mom telling the truth.
Mhm.
So I don't think the deal falls outside of the question that I would ask you, which is, are you aware of any cases where there was a reversal on appeal, on a trial day motion to continue, where there wasn't a name of the attorney mentioned and the attorney was either already retained or physically appeared in the courtroom to ask for the continuance? Are you aware of any?
Off the top of my head, of those cases that you're citing to, no.
So,
But
so,
I'll-
so then that would put us in the position as the sixth DCA, talking about first principles, we would be the only DCA to have reversed on an issue such as what you're raising here, where there was no name of an attorney mentioned and the attorney was neither retained nor personally appeared in court. Would that be correct?
I don't know if that's correct, because I don't want to go ahead and say that there's no case out there. But I would say that in these other cases that the attorneys had withdrawn at that point in time. So in a way, we have the same exact circumstance. So in Barcasell, we had a situation where they had filed an appearance.
Yes and no. Yes and no. I mean, what I'm looking at here and my challenge with this is that you've got multiple prior continuances that have happened in this case. You have an effort by a defendant to say, I want a continuance, I want to get private counsel. And then he makes this quizzical statement. I talked to this guy for 30 minutes and he fully understands my case, which I think every person on this panel would think that's a little crazy to make that sort of a representation to a court. I don't think any attorney would make that sort of a representation. And then we've got no name, no retention, no facts in the motion saying, and judge, this is how I'm going to get the funds to retain this person. Nothing, just a judge. There's this person that I spoke to on the phone and I want a continuance. He really understands my case. I don't find any cases that support that even being cognizable as a good faith motion to continue. Why should the trial court have to sit there on the record every time something like this happens and say, okay, stop the presses. Even though this is so obviously not a good faith motion, I'm going to find it's not good faith because they didn't mention the name. He hasn't given me any plan for retention. This attorney has not appeared. Why shouldn't we go that route?
Well, you're supposed to do an inquiry. So had these questions been asked and had that inquiry occurred, then maybe we'd have more understanding of what efforts were taken to retain counsel and provide names. But the court cut them off, said, no, we're ready. We want to go today. We're going today. There's no inquiry. I would point also to during the Nelson proceeding, the appointed counsel did mention that the family had reached out to him to advise him that they were in the process of retaining counsel as well. When it all comes down,
Which case? That wasn't this case.
that was this case.
Okay.
During the Nelson proceeding, appointed counsel mentioned that the family had contacted him basically after they had met November 10th. Or not November 10th, November 1st, with Mr. Gibson, and told the attorney, can you get a continuance because we're trying to retain counsel? And the appointed counsel said, no, I'm not going to do it. So I don't think that the attorney being named when there's no sort of inquiry and no finding
It's
of
kind of like
bad
a
faith.
proffer, right? If the trial court doesn't let you, normally you got to do a proffer, but if the trial court doesn't let you do the proffer, cuts you off while you're trying to talk, you can't say you didn't preserve because you didn't do your proffer if you weren't permitted to do a proffer. If you're trying to discuss why you need a continuance and give details and the trial court cuts you off and doesn't let you give the details, you can't really say, oh, well, he didn't give details.
Exactly. And there was no recognition that he had that right. And that kind of brings us to the second point, because when you look at how this trial judge was conducting the trial, it was not to give Mr. Gibson opportunities to explain himself.
I don't want to cut you, but I want to hear from you on Freda before you run out of time. All right, so we've got this statement in Weaver. Okay, and it says, a defendant who persists in discharging competent counsel after being informed that he is not entitled to substitute counsel is presumed to be unequivocally exercising his right of self-representation. Now, it seems like your client fits within that statement. Okay, he said he wanted to fire his counsel, so he tried to discharge his counsel. And he was told previously during the Nelson hearing, I'm not letting you get out of counsel. If that statement is a holding, I think you got a really strong argument. If it's dicta, I think we're not bound by it, and we're looking at this from first principles, and then it's just, we're looking at kind of general Pareto law and trying to figure out what binds us. So can you give me a Pedroza analysis, or however you'd like to discuss it, on Weaver as to why that statement is binding on us?
Well, I'd like to, in Weaver, perhaps it is dicta, but if you look at the cases cited to by Weaver, it goes ahead and cites the other.
Are you saying you
decisions.
think the statement is dicta?
I'm saying that it could be construed as dicta in that case. But ultimately, when we look at the decision itself, it cites to other Florida Supreme Court case law. And in those cases, I think it makes it more clear that this is not a dicta statement, and that is a principle by the Florida Supreme Court, that when you make that.
All right, so if you don't think that statement is a holding, then take me through which gets, there's language in various cases that support your argument. The question is whether those are holdings or dicta. So if you're not confident Weaver is a holding, or at least the statement in it that helps you, which cases are you referring to, and which language are you saying is a holding rather than dicta? Because I think, Weaver helps you, Jones helps you, Mosley helps you, but in terms of some of the statements, but which of those statements are holdings that you think we're bound by, and why?
So I think Mosley is probably the best case for the proposition. And in Mosley, essentially there was a death penalty case, and prior to the Spencer hearing, the defendant made a similar request in the case for self-representation. And the court went ahead and found that it was error to.
But in that case, didn't he say, I want to represent myself?
I had to go ahead and look on rebuttal. I'll take a look at it and let you know.
Well, in Mosley, he specifically filed a motion that says, and I quote, unequivocal demand to immediately represent myself. So I would call that an unequivocal
Correct.
demand to represent himself.
Correct. That's why that statement in Weaver is so important for you, because Weaver basically says a statement like the one your client made here, even though he didn't say, I want to represent myself, constitutes an unequivocal demand. It says defendants who refuse appointed counsel but do not provide their own and are presumed to exercise the right to self-representation, even though they don't say it. So that's kind of the piece. I agree with you. If somebody makes an unequivocal demand or says, I want to represent myself, you got to have a Pareto inquiry. Your client didn't say that. And so it seems like you need some kind of holding, like the statement in Weaver, if it was a holding, saying that what your client did here puts you in the Pareto bucket.
Well, Your Honor, I'll take Weaver as the case then.
All right, well, then you got to go back to my original question. I asked you, explain to me why it's a holding, and you said, I'm not confident it's a holding.
But let me go ahead and look at it during the
Okay, why don't you do that?
rebuttal period. I'll come back to it, Your Honor. I'd just like to go ahead and briefly touch on, the third issue, because it also dovetailed into his right.
So you've got 2 minutes left. Do you want to use another third issue, or do you want to?
I'll reserve it, Your Honor. Yes, thank you.
Good morning. My name is Robert Bradford, and I represent the state of Florida in this matter. I think it's important to realize, with respect to all of the first three issues, that the appellant in this case had an issue with both stand your ground law and self-defense. He seemed preoccupied with the fact that the victim's girlfriend, Mills, was the initial aggressor here. In fact, he raised that at several points throughout the trial, including at the Nelson hearing on the morning of the trial. That's one of the reasons why he felt his attorney Klein was incompetent, because he hadn't done anything to depose the witness Daniels, who apparently had some information that Mills was a fighter or had a reputation for being a fighter. But the problem with that is none of that's material. It doesn't matter if she was a fighter. It doesn't matter if she had a reputation for fighter, because there was no evidence to support that he knew of that reputation.
So can I ask you to get to the Pareto issue? So I want to ask you the same question. I think this statement in Weaver is really helpful to them and unhelpful to you. Okay. The question is whether that's a holding or dicta. Okay, if it's a holding, I think his client pretty squarely falls within it. If it's dicta, then we're not bound by it, and we're looking at this from kind of right of first principles, right? Well, that's a much more complex analysis. This statement in Weaver, a defendant who persists in discharging competent counsel after being informed that he is not entitled to substitute counsel, is presumed to be unequivocally exercising his right of self-representation. He did that, right? He said, I want to fire my lawyer. So he tried to discharge competent counsel, and he had been informed he wasn't going to get another lawyer previously. So I don't see how he doesn't fall within that statement. Tell me why that statement, from your perspective, if you think I'm wrong as to whether he falls into it, feel free to tell me that and explain why. If you think I'm right that he falls within that statement, tell me why it's dicta as to Weaver and we're not bound by it.
First of all, I don't think it's the holding of the case. I unfortunately cannot tell you as I stand here today why it's not the holding of the case.
Then other than it being bad for you that it's the holding, if you can't tell me why do you think it's not the holding? Is it just because if you give that answer, you think you lose?
No, first of all, I think that's, and this kind of has to go back with the first issue on the continuance, is we're debating a couple of issues today and whether to elevate form over substance. And we shouldn't do that because, I mean, that's almost like a return to code pleading. With respect to the continuance, if the record is clear.
Stay on my question. I'm a Freda and Weaver. Give me whatever you can, the best that you're prepared to give as to why that statement is not binding on us, why it's not a holding that we are required to follow. Or if you think I'm wrong that he falls within the statement, you can explain that too, but stay on that issue.
I don't think, as I recall reading that case, I don't recall that was the operative mechanism to resolve the case. It wasn't the holding of the case.
And counsel, in Weaver, did the trial court tell the defendant expressly, if you proceed with discharging your attorney, you will go forward pro se without an attorney? Was that actually told to the defendant in Weaver?
As I stand.
And if you're
today, Your Honor,
confused, the answer is yes.
I
The trial court did tell that to the defendant in Weaver. And my question to you is, did the trial court tell that to the defendant here? Did the trial court expressly tell the defendant Gibson that if he fired his attorney during the Nelson hearing, did the trial court say, if you do this, you will be proceeding pro se?
No. The
Okay.
trial court did not.
So does that then distinguish us from Weaver?
There is a factual distinguishment in that sense, Your Honor. I also would offer to the court that this whole entire issue was not properly preserved for appellate review. Under the Rutledge case from the first DCA, and I cited that case in my brief for the purpose of the fact that it can be harmless error when that advisement, that notification is not given. But the Rutledge case on page 1126 talks about the fact that in that case, the state had correctly argued that the appellant in that case had to prove fundamental error because they did not preserve they did not make an objection at trial in the circuit court and give the circuit court judge an opportunity to rule on them and to correct its own mistake in the first place.
I don't understand lack of preservation. He said, I want to fire my lawyer. I mean, all right.
He never said that.
Yeah, he did. He said, I want to fire my lawyer.
Oh, I'm sorry. Yes. He said he wanted to fire his lawyer. He never said he wanted to represent himself.
Well, but that's the whole point. That statement in Weaver says he doesn't have to say that. It says defendants who without good cause refuse appointed counsel. I'm sorry. A defendant who persists in discharging competent counsel, right? Which is what he did. He said, I want to fire my lawyer. After being informed that he is not entitled as a substitute counsel, is presumed to be unequivocally exercising his right of self-representation. So that's my whole point. That statement in Weaver seems to say he doesn't have to say, I want to represent myself.
If the court focuses on individual trees, we're going to get bogged down in some.
Counsel, this isn't trees. This is this a holding? There's a mechanism to.
That's what I'm trying to explain to the court. There's an overall arcing of the facts in this case where appellant had hired his own attorney, Attorney Mills. Attorney Mills worked 2 years, not a peep out of him with respect to dissatisfaction. He worked for 2 years. He filed the Sandra Ground immunity motion. He didn't get that right because the appellant was afraid of admitting that he actually killed the person.
Counsel, you're giving me an
So-
analysis of this case, and that's important. But what I need is an analysis of Weaver. I need to know whether that statement is a holding. The Supreme Court has set forth a mechanism for telling us what the holding of cases in. It's set forth in Pedroza.
Do you stand by your earlier answer that you're not prepared to do that today?
I don't have anything else to address that with respect to the holding in specific, other than the factual distinction between the two cases. And the fact that this one is not preserved, and the fact that the Rutledge case can say it's harmless error. If it can be harmless error, then it can't be a holding that says you have to do it in every case, and every time it's not done, it's reversible error. It can't be. It doesn't work that way. The Rutledge case, they found harmless error because Rutledge had never challenged the denial of his discharge motion after following the Nelson hearing. And he never actually requested to represent himself. That was the harmless error that the Rutledge court found. That's exactly what we have in this case. He never said, I want to represent myself. He clearly, throughout 3.25 years of litigation, said, I need an attorney. He had one, Cashman, appointed. She worked for 90 hours, got a bunch of preliminary stuff done. He then goes out and hires one. For 2 years, they prepare this defense, this strategy. They lose the immunity hearing. Now I'm not satisfied with this attorney. So he had 3 months to hire another one, didn't choose to do so. Lets the court appoint Attorney Klein. Attorney Klein comes in, and by the time 7 months later, he still hadn't said anything. A week before trial, he writes a letter and says, I need, this attorney is incompetent. I need a new one. It's a theme. It supports the bad delay or bad faith and delay tactic conclusion, not that the trial court made, but certainly is there supported by the record evidence. And with respect to not being told that you have the right to appear pro, or you might have to appear pro se if you discharge this counsel, he never asked to do that. He never asked. In fact, he had just had a Nelson hearing seeking to discharge this attorney, and he said, all I need is 30 days, Your Honor. Give me 30 days continuance. I'll get another attorney. I've already talked to him. He never at any time said, I want to represent myself. So if this court imposes an obligation on all the circuit courts in this district to then have a formal inquiry or be prepared to lose every ruling if it misses this case.
To me, the question is whether the Supreme Court has already imposed that, right? And whether we're bound by it. And it's kind of, this case was in the briefing, and it's a Supreme Court case that's kind of directly relevant. So for you to come here and just say you're not prepared to discuss, it's really not very helpful, right? It's not like it came out of nowhere. The case was central in the briefing, and it's a Florida Supreme Court case right on this issue. I'm looking at Weaver, and in Weaver, the issue was whether the trial court properly gave the Friday inquiry, right? The court gave the Friday inquiry, and he argued there shouldn't have been a Friday inquiry. And so the Supreme Court had to look whether or not it was proper to give a Feretta inquiry, and found that based on what had transpired in that case, the fact that he tried to fire his counsel after being informed he wasn't going to give new counsel, that he had made a request for self-representation, and therefore the Feretta inquiry was proper. That seems to me to put that statement in the line of decision that was critical to the judgment, right? And that's kind of the test we use under Pedroza for whether something is a holding. And so, I'm interested if I'm wrong about that, but we've got a Florida Supreme Court case in the briefing, like directly relevant to the central points in the case, and they come to oral arguments, and I'm not prepared to discuss it.
Your Honor, he didn't ask to represent himself. He just told the court he has another attorney he's already talked to. He wasn't asking to represent himself. The Florida Supreme Court, I don't believe in Weaver, imposed that line in the sand. I don't think they drew a line in the sand and said in every case, you have to say this, and if you don't say it, it's reversible error. You lose the convictions. Attorney Klein, one of the complaints that the appellant had in this is that Klein had no strategy. And Klein told him that the appellant was afraid of going to trial. This was the third time he'd shot somebody and had to go to trial for it. He was afraid of the surveillance video. The surveillance video is clear.
Counsel, let me ask you a question.
Yes.
Are you aware of any case where a person said, I want to fire my lawyer mid-trial, and the conviction was overturned because of a failure to conduct a Feretta hearing?
Requests made during trial are untimely. I know no such case. With respect to going back to the continuance, in addition to the bad faith, what I've tried to paint a picture is that the record does support the fact that there was no reason to have a continuance. He was making a bad faith continuance request. He was.
Counsel, say I agree with you completely that there was ample evidence to support the trial court's ruling. I'm concerned that the first and the fourth have said there needs to be an inquiry before that ruling is made. Okay, that seems to me to be what they've held. If we agree with you, even if we think there was tons of evidence to support the trial court's ruling, if we say that it was okay for there to not be an inquiry before she made that ruling, are we not in conflict with the first and the fourth? Which I'm not saying we can't be in conflict, but I'm just saying, do we need a certified conflict in order to agree with you on that issue?
No, the holdings of those cases, those are not the holdings of those cases. They may have found an abuse of discretion in those cases, but they didn't say that the failure to make those findings or the failure to have such an inquiry is an abuse of discretion.
So I've got
What the
from the
Madison court
fourth,
said.
hold on, I've got from the fourth, any denial of an accused request for a continuance to retain counsel of choice must be based on an adequate inquiry into the surrounding circumstances and proper findings. So the fourth, that's the fourth, that's the deal, has said there's got to be not just an inquiry, but findings. I mean, I'm seeing Foster says the same thing, right? Was
Yes.
the trial court made no such determination, right? The court didn't examine it. We've got Madison, where the court said, here's all the factors that have to be considered. So I'm not saying what, in terms of the merits of decision, I could totally see your argument as to why there was ample evidence to support the trial court's decision.
Your Honor,
I'm just saying, are we not dealing with the first and the fourth, saying that there had to be some inquiry before she made that holding or that decision?
the Madison court, which is a fourth BCA case, Your Honor, said that the order denying a continuance without such an inquiry is more subject to reversal. Not subject to reversal, more subject to reversal. That suggests to me that it's not 100% of the time. The Val Purcell, apologize for my pronunciation, said not every request to substitute counsel on the eve of trial may be denied without an inquiry. That tells me some can. If they said it's one way or the other, this language would not be in the opinion. And the Perozzo opinion, I think, while it does talk about how important it is, it goes back to the purpose for such an inquiry, and that is to determine whether the continuance denial was arbitrarily imposed. In this particular case, it clearly was not. He had fired or tried to fire every attorney that didn't implement his defense strategy that he wanted to implement. He did it to Mills after he lost the immunity hearing. He tried to do it to Klein after Klein tried to bring out Christina Mills was a fighter in the trial. Objection, proffer. Comes back in, I want to fire my lawyer. Don't say that again. I want to fire my lawyer. It's a delay tactic. It's bad faith. I think it's very clear that the court is not required to elevate form over substance. And that's what appellant is asking this court to recommend. With respect to the stand your ground hearing testimony from Ms. Mills, I'm pretty sure Ms. Mills was not called to trial because she made a terrible witness. If you look at the video, she pretty clearly is instigating this. In the video, there's a line of parked cars, an open area. Victim and Ms. Mills come out and get in their car very clearly on the camera. Victim comes in, Alan comes in, parks his SUV. There's plenty of room for them to get out. In fact, they do. They do pull out. They have to stop because there's people walking around getting their cars. And after they sit there for a minute, Ms. Mills gets out of the car, goes back, starts saying something to the appellant, and It's obviously words are said back and forth. And then when somebody walked, it would appear to me that there's some elevation in the tone or the volume, because then people start coming in and somebody even walks up to her, and about the time they walk up to her, that's when she goes after him. But he pushes her back. So she clearly is the initial aggressor. But I don't know of any case or any aspect of Florida jurisprudence that said because a girlfriend takes a swing at you, you get to shoot her boyfriend in the face. Her unarmed boyfriend. Now, appellant and the victim about the same height. With respect to her testimony, with respect to her testimony, it's not material. It's not material to the elements of the charges. It's not material to the defense. She's clearly over here in the video. The victim's over here. Appellant is standing in between, beside his car with the door open after he retrieved his firearm. He's going with no shirt on. He comes around the door, at least past one person, possibly two. You never see his arm up like this, where he says he brought it down and tried to hit him over the head and gun it off. What I saw is a punch. Now, he may have tried to punch him with a gun, or he may have just tried to shoot him. I don't know. It's very quick, very happy. But her testimony is not material to any aspect of this case. So he couldn't have read that testimony into the record. It would only have done one of two things. It would have supported the video evidence, which, so therefore its conclusion is not prejudicial. Or it would have conflicted, and they would have been admitting the testimony, basically calling the witness to impeach her, and that's not proper. This would be testimony that she's a drinker and a troublemaker, and it's improper character evidence, and it's not admissible. And again, even if it was any error in excluding it would be harmless because of the fact that it had no materiality whatsoever. The last issue also was not preserved for review. They failed to give the proper instruction. Just with respect to that, I'll say that the instruction that was given did not misstate the elements of any offense. It did not misstate the burden of proof. If I am correct, I believe they gave the old instruction that was then later modified. Not that it was incorrect, but that the Supreme Court just found a better way of saying it. As far as the burden of proof, they said that the justifiable use of deadly force is not a crime. The state has the burden of proving the crime, and the defendant didn't have the burden of proving anything. So with that, I would ask the court, unless you have any more questions, I would ask the court to affirm in all respects.
Thank you.
Thank you.
May it please the court. Going to Judge Mize, your point. So in Pedroza, in order to determine whether reasoning is dicta, you look at one, are actually decided, two are based on the facts of the case, and three leads to the judgment. So I think Weaver is not dicta. When we look at Weaver, as your honor recited, it was determining whether a FREDA inquiry was correctly done in the case.
And counsel, let's say I agree with you, but it's not dicta. But let's look at the sentence itself in context, because I think context is important here. The specific sentence in Weaver says, a defendant who persists in discharging competent counsel after being informed that he is not entitled to substitute counsel is presumed to be unequivocally exercising his right of self-representation. That's the particular quote. The facts of the case that the court had just clearly recited were that he was told, if you proceed with firing your lawyer, you will be going pro se, sir. Do you understand that? Don't you think that what the court was really saying was, in shorthand, after being informed he's not entitled to substitute counsel, wasn't that just shorthand of the court saying he had a mentality of knowing he was going forward unrepresented from that point?
Yeah, I mean, absolutely.
Well, and if that's the case, if that's what the court's saying, that he was going forward unrepresented, in this case, in Gibson, was Mr. Gibson ever told he was going to go forward unrepresented if he fired his attorney?
Explicitly, no. But
all right. So let's say that he was not explicitly told that. So then doesn't that take us outside of the holding of Weaver?
No, it doesn't, because he was essentially told that. When you look at what happened in the case, I want a new appointed counsel. No, you're not going to get that. I want a continuance to retain private
No,
counsel.
but
No, you're
the
not.
court specifically said, no, you're not going to get that. You're going forward with this lawyer. That's not what happened in Weaver, right? The court said, if you fire this guy, you're not going forward with no lawyer, you're going forward pro se. The court in this case said, you're going forward with this lawyer, your lawyer, the person sitting right next to you.
Well, I think when he's making that request, I want to fire my attorney. That's the only option that was available to him, is to go self-represented. And there was no inquiry done. She cut him off. She said, if you say another word, I'm going to go ahead and make sure that you can't. So when we look at what happened in this case, although it wasn't explicitly, that was certainly implicitly. And if the court does go on that line, that points us to the third issue, where the Nelson requires the court to go ahead and say, I'm not going to discharge counsel. And if you do so, one will not be appointed to you.
Required to say that, right? The court should have said that
Correct.
under the Nelson case law, with the exception of Rutledge. So we get to the Rutledge case, and in the Rutledge case, the court was faced with exactly that scenario where there was a request to discharge an attorney. The defendant was not told that he was going to be going forward with self-representation if he discharged the attorney. And in Rutledge, the court said, the state convincingly asserts that any error in the failure to advise is harmless beyond a reasonable doubt, given the facts that appellant did not challenge the finding of effective representation and never expressed a desire to represent himself. Isn't that exactly what we have here? He has not challenged on appeal the effectiveness of his representation, and there was never an expressed desire for him to represent himself.
I don't think it's talking about, can I respond, please, Your Honor? I know that I'm out of time.
Oh, of course, yeah.
So I don't think it's, did you argue it on appeal, but did he argue that he wanted different counsel, was dissatisfied with counsel at the relevant period of time?
Not dissatisfied, ineffective.
Yeah.
I mean, it specifically says you got to challenge the finding of effective representation. The Nelson finding of effective representation has not been challenged, right?
I think
Hasn't been challenged.
Mr. Gibson challenged his representation throughout the entirety of the proceeding. Immediately upon Nelson.
It's the finding of effective counsel.
Correct.
The court
He
says you have
did
to
that.
challenge.
Judge Smith is saying you didn't challenge it on appeal. You don't assert on appeal that his counsel was ineffective. You
Well-
assert he thought his counsel was ineffective at the trial level, and that Nelson inquiry wasn't done properly. But you don't challenge on appeal the fact that the trial court's finding that the lawyer was in fact effective.
Well, we can't bring that up on appeal because it's prohibited by the Florida Supreme Court. So, but certainly, he showed dissatisfaction immediately upon.
So did Rutledge, though. Rutledge did the same
I
thing.
don't-
He filed a Nelson motion and tried to get his counsel discharged, and the court said no.
But
That is why I'm saying Rutledge, we have the exact same facts. We have a defendant who said, I don't like my attorney. I think he's ineffective. And the court said, no, you're wrong, just like with Mr. Gibson. So that's all been there. But then the court throws this sentence in there that says, given the fact that appellant did not challenge the finding of effective counsel. So just doing the Nelson, I don't like my counsel, obviously was not what the court was talking about when it says the appellant did not challenge. And it uses the word appellant.
So I think that our case is different than Rutledge, because in Rutledge, there was no indication from the decision that after that was done and the second part of Nelson wasn't complied with, there was no assertion by that defendant in Rutledge that his attorney, he went to go ahead and seek to discharge him later on, or he tried to go ahead and become self-represented. And so that's where it becomes, harmful in this case. It's because Mr. Gibson did those things. He did show that he was dissatisfied with his attorney throughout the trial, and he had legitimate concerns. And that, I can go ahead and go into that further, but his concerns were legitimate throughout trial. Defense counsel did not move for the blood alcohol content level of the victim in the case to be admitted. This is a self-defense case. If someone is drunk and belligerent, you don't think the jury should know that they're drunk and belligerent when you're trying to deal with that person. When you're looking at Mills's testimony, of course you want to introduce that into the evidence, because there was no other evidence as alcohol consumption in the case based off of it. And the reason why it wasn't introduced is because defense counsel thought, I can't do it. And that was it's plainly wrong. Even the state hasn't argued that he wasn't wrong on that. So at the end of the day, all these issues with right to counsel, self-representation are per se prejudicial and mandate this court reverse for a new trial, regardless of what happened at the trial itself. So we'd ask for the court to grant a new trial in this case.
All right, thank you.
Thank you.
Thank you both for your presentation. We'll take the case under advisement. We'll be in recess.